Oh my goodness. Christina Montez. Yes, nobody wants to see your boyfriend or whoever that is half dressed.
And it appeared as though you were having on the screen.
No.
If I accept your plea, I have to advise you that if you commit misconduct between...
Wow.
Yeah, wow, you should see the video.
They keep interrupting me. Motion
Sorry, I was
denied.
never trying to interrupt you. You're
Motion
very
denied, writ
biased.
may issue. Thank you.
You're very
I'm done.
biased and disrespectful.
I'm done.
That doesn't matter. You're
I
disrespectful and
am
you're very
done.
biased. You need to do your
I
job. You don't
am
know how to do your
done.
job.
I've been sitting here for 3 hours. And I sat in your courtroom for 4 hours. I understood that you're going to take a break and go to lunch, or...
I heard you. I heard everything what you said. You don't got to explain it no more. I heard you, bro.
Yeah, I'm not
You live and
bro.
I will be there.
I am not bro. I will never be your bro. You do the same, bro, too. What?
In attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
No, Your Honor. Well, she doesn't have much of a record. She had a state jail offense several years ago, and we're just asking that you grant her the deferred adjudication.
All right, Ms. Ruiz, I'm going to ask you some questions. I need you to be honest with me because I need to figure out what conditions to set for your probation. Do you understand?
Yes, Your Honor.
All right. So the questions I'm going to ask you, know that I'm going to have you do a test anyway. If you're tested for drugs today, what are the results? And know for a fact that you are going to be tested today. So what are the results going to be?
For a UA.
And don't start with just marijuana, because everybody says that because they think it's okay to use marijuana because people are legalizing it. So what are you going to be positive for today?
I'm going to be positive for marijuana.
And what else?
That's it. That's all I do. That's all I just smoke.
All right, you're gonna get a UA today, and that UA had better only be positive for marijuana. If it's positive for something else, we're gonna have a problem. When's the last time you used meth?
I don't use meth, ma'am. Like, I just smoke weed. That's all I do. Like, I've never been charged with this type of drug or anything like that. Like, this really wasn't mine, ma'am. Like, it was in my possession. Yes, it was in my vehicle, but it was not mine. And that's the honest to God truth.
All right. You're gonna, do you have any children?
Yes, ma'am.
What are their ages?
3, 4, and 9.
Do they live with you?
Yes, ma'am.
Is Child Protective Services involved?
No, Your Honor.
Have they ever been involved?
Yes.
All right. Are you employed?
No.
How are you supporting yourself?
Well, since the whole pandemic and everything started, my kids have been out of school and I don't have anybody to care for them. So I've been the only provider for them here.
I'll say, so I'm back to my question. How are you supporting them? You don't have a job.
No, well, right now I'm on Section 8 and just the help that I get from the government. That's about it. And currently right now I've filed for child support, but that's about it.
When's the last time you had employment?
I'm gonna say about a year ago, maybe. It was a little after I had my son.
Doing what?
Maybe like a year and a half ago.
Doing what?
I think it was at Fred's Fish. I think that was my last job. It was Fred's Fish. It was Fred's Fish or J. Anthony's.
All right, they do have employees at Fred's Fish Fry. Okay, that has always been a question for everybody. All right. How far did you go in school?
I only went to freshman year to 9th grade.
Do you have a degree? Did you graduate? Did you
no, I didn't.
You have a GED?
No, I don't.
So you're just having children.
No, I'm not just having children.
The taxpayers, which is everybody on this screen, is supporting them and supporting you. So I'm gonna put an end to that. This is what we're gonna do. It's $1,500 fine. $1,500 fine, that will be probated. 2 years deferred adjudication. You're going to do a UA today by 2 p.m. And probation, I'm going to want her tested for levels. You're going to take parenting classes because when you were out and about driving, I don't know where your children were, but they were not in the vehicle with you. You're going to have proof of employment within 30 days, 120 hours of community service restitution. You're going to obtain a GED or go to some type of trade school or do something with your life. You understand? There's going to be random UAs. And I'm going to want field visits.
Your Honor, no disrespect, but like, how are you like saying all this about me when you don't even know anything about me?
Let me tell you what I know
Like, you're
about you.
just telling
Let me
me
just tell you what I know
because I'm
about
on
you.
Section 8,
Yep.
it means that I'm living off of the government, that I'm not being a good mom to my children. That's what you're
Let me
like
ask you
saying
this.
about me right now.
Yeah,
And I
yes,
feel
I
very
am. Let me just tell you what I'm
disrespected right now.
saying. Let me ask you a question. You just told me you're going to be positive for marijuana. Is that correct?
Yes.
All right. So here's the thing. Let's say you need a babysitter for your children.
Ma'am,
And
I
the
know
children, nope. Let me finish.
Yeah, you
Because
need
you're
to let her
you're
talk.
trying to tell me you're such a great parent. Let me ask you this. You need a babysitter for your children. She's the Mary Poppins of babysitters. She comes to your house, your children love her, and she tells you, hey, by the way, I smoke marijuana. That's all I do. And if you test me today, I'm going to be positive for marijuana. Are you letting her babysit your children? Are you letting Mary Poppins, who's telling you she's going to be positive for marijuana, babysit your children? Yes or no?
No, ma'am.
Yeah, well, you're the Mary Poppins who's positive for marijuana, babysitting young children, who has no job, who's had CPS in your life, who was driving around with marijuana in your vehicle. And yes, you are not supporting yourself. The people who are supporting you right now and supporting your children are taxpayers. You just told me your children, you don't have child support for them. So the father's not supporting them. You just told me you don't have a job. You're not supporting them. You just told me you're going to be positive for marijuana. So you tell me, what is the description of a good parent? Is it somebody who has no job, cannot support their own children, depending on taxpayers, and positive for marijuana?
No, Your Honor.
So that's what I know about you right now. So I'm going to help you straighten your life out. So hopefully your children will lead a different life. Because right now, the only example your children have on how to be a good parent is you. And the example that you have given them is, I can't support you. I need taxpayers to support you. I've chosen fathers for you who will not physically support you. I've had CPS cases, but I can use marijuana. So this is what we're doing. $1,500 fine that's probated, 2 years deferred adjudication, a UA 2-day by 2 p.m., parenting classes, proof of employment within 30 days, 120 hours of community service restitution, and that will not be waived under any circumstances. She is to do the 120 hours of community service. You're going to obtain a GED or get in some type of trade school, random UAs, and I want field visits at her house because obviously Child Protective Services is not visiting her and somebody needs to look out for these children. And there's going to be outpatient treatment. Is there anything else you feel you need to be successful on this probation?
No, Your Honor.
Probation, is there anything else she needs?
No, just make sure you add the 57 for Bear Lab, please.
Thank you. And $57 to Bear County for laboratory testing. Next. Oh, and the other thing, Rebecca, I'm going to want weekly Zoom reporting until further notice.
Yes, ma'am.
And make sure those field visits are at least once a month. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. I'm sending you to a breakout room. Probation will go over conditions with you. And Miss Lee, you can go to the breakout room with her if you so choose. Otherwise, you are excused.
Okay, thank
Oh, there you are. Hello, state your name.
Here, Morris.
All right. This is your request to set aside the default.
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing.
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed some to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arbor Woods paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Dornbush?
well,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My rent was supposed to go up in August. I'm sorry.
There was, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, there was So what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the
Yeah.
hearing on, I think, November
Correct.
17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms.
That's
Morris was
absolutely not true,
100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can pull up the ones that I have and I can send it back into the court.
Ma'am,
So
I have your signature
mhm.
on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing. And it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
and I'm
and it did
confused
not
on the
get filed.
motion.
It
Go
did
ahead.
not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes,
So-
I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff and we're trying to come to a resolve. So my information hasn't changed. And my issue hasn't changed either. And if we would have been in court in May, because that ledger says that I had a balance.
Ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct, the same
So-
day, Judge. Ms. Dornbush is not
But-
acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of 2025.
Do you see that on the account, Ms. Dornbush?
I do see that, Your Honor, and I believe, I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June, payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well, sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it, and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed, because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand that
what is her current balance?
The current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in
I know
September.
that.
Okay,
So
I'm saying in
you tell
September.
me,
Yeah.
taking out all of that, how much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was $360.
Did you pay December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as well.
I've got 700. So you're saying that if I take that 700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your Honor.
You can say absolutely not.
Where
if you
is
look
that
at the
going to
first.
come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right. So in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so
that's
even if they
$85
did
per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is $55 that gets charged on after the 5th, and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Ms. Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen to me.
If you look on my ledger,
listen to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm asking you for where that discrepancy is.
Okay,
you
sir.
are giving me 150. I'm not agreeing with you. I'm just saying, where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out a letter saying I owe $1,660.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You have given me a total amount of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually put it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow. In November, my rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266. Sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was supposed to start in August.
Ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense for me, but it makes sense from the attorney? You're being biased.
I'm done. You're not
You're
going to
biased.
interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry,
denied.
I was never trying to interrupt you. You're very biased.
May issue. Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and you're very biased. You need to do your job. You don't know how to do your job. That's all.
I am done. Motion denied.
Your Honor, I would request that the money is held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney. You have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her out of the.
Mr. Caldwell, can you unmute your mic and state your name for the record?
Demetrius Cole.
All right, thank you. What are we doing?
Your Honor, the last time we were here, we scheduled this matter for a forensic interview. That date has came and it has passed. Unfortunately, Mr. Caldwell did not make it to that interview. We're going to need a re-referral.
Your Honor, I think this is at least the second one he's missed.
Yeah, why is he missing the interviews?
Your Honor, I am unsure as why the one was missed on November 3rd. I did have an opportunity to speak with his guardian ad litem, Ms. Graham, who is on here today as well. She's also unaware as to why it wasn't made. Everything was set up for him to appear. He just did not appear. So I'm unsure as to why not, and I know that Ms. Graham is unsure as to why not as well.
And I do think it's actually the third one as I look through the notes in my file. It's at least the second one I know for sure. Your Honor, I feel on behalf of the people, I'm in a different position.
Go ahead.
And at this point, we have to get this moved along, and Mr. Caldwell has not appeared. I understand he has mental health issues, and there are difficulties. But at this point, I am going to ask. He has violated his bond conditions by not complying with the court's order to appear for the forensic interview, and I'm requesting a bench warrant. I don't know if we're going to get it done without him in custody.
Well, it looks like 3 to me.
Your Honor, what had happened, I came in, I replaced a prior attorney. You actually appointed me to this matter. And the first one was, I don't know if it was the first or the second, but one was set and they did not notify me. They notified prior counsel. So that's when they messaged us to reschedule that one. That one was missed because of the, there was a mix up with paperwork, but in this one, so this was the second one that's for me, Your Honor.
Okay, here's what I'm going to do. I'm going to indicate that the defendant is to surrender to the Washington County Jail. Oh, somebody else has their hand up.
I think they lowered it, Judge.
Your Honor, that's Yvonne Davis. She is the owner of Elite Guardianship, who I work under.
I'm sorry, she is the
owner of Elite Guardianship, the company that I work for. So she also
ma'am.
Is. So that's why she has her hand up.
Okay, is there something you wanted to tell me, Miss Davis?
Yes, Your Honor. So unfortunately, Mr. Demetrius Caldwell has been very difficult to get him to any appointments. His behavior is disturbing, at least. He's been very disruptive at CMH as he is right now, waiting for his court case. He's technically homeless, and getting him to another appointment is basically impossible. So I wanted to add that.
Okay, thank you, ma'am.
Yes,
you're welcome.
Your Honor, can we do something soon, because I can tell he's getting a little agitated with Miss Nina that's there, and he's already thrown a chair while he's been sitting there waiting on you in the courtroom.
Where is he right now?
CMH on
Talk to them. Please talk to them. Can you please talk? I did not throw no chair or nothing. I've been sitting here chill all day, bro. Why is y'all on me like that, bro? I did not do nothing wrong. I'm not doing nothing wrong. I've been sitting here all day trying to get up out of here, waiting for my appointment.
All right, Mr.
I'm not doing
Caldwell.
nothing, bro.
Okay, hold on. He's talking.
I've been chilling, like I'm not doing nothing wrong.
Okay, Mr. Caldwell. Mr. Caldwell, you'll need to come back on the screen and sit down, sir. All right, thank you. So, Mr. Caldwell, our problem is that we've got to have you get to your appointment, and you can't get there.
Okay, I literally said I will reschedule it and go to it. I literally just said that. Like, I've been saying that.
Okay, but hold on, Mr. Caldwell. We've done that twice now. Okay, and you've got to get to the appointment, otherwise we can't do anything, and then I've got to do something I don't want to do.
Okay, I said I will reschedule it and go to the appointment. Can y'all reschedule my appointment so I can go? I just said that I will literally go to my appointment.
Okay, I'll tell you what, Mr. Caldwell, here's what we'll do.
That's all I said. Been said, been done. Said.
Mr. Caldwell,
I mean, I'm
listen to me
I'm listening.
now. Listen to me.
I'm listening.
All right. I need you to come down to the courthouse. I'm going to set an in-person hearing where I can make a decision on how we're going to get this done. I'm going to set it for next week, the 11th, 2025 at 9 a.m.
Now,
So you need to come
all
down in
down to the
person, and then I'm going to decide how we're going to do this.
All right.
All right, but you got to be here.
I will
And
be there.
what
You
I
said
don't,
11. You
and
said 11.
Mr. Caldwell, hold on. I don't want to have any of those reports of that behavior that they tell me that you're doing. You got to behave yourself. Mr. Caldwell?
I'm listening.
What did I just say? Okay. I'm not blaming you. I'm not making, I just don't want any reports of that. I'm going to give you a chance to come down here so we can try to work this out.
I heard you. I heard everything what you said. You don't got to explain it no more. I heard you, bro.
Yeah, I'm not
11,
bro.
I will be there.
I am not bro. I will never be your bro.
I didn't say bro. I said all right.
Do not refer to me that way, because we're going to have a bigger problem.
I didn't say bro. What are you talking about? I said all right.
Your Honor.
Your Honor.
Thank you.
Your Honor.
We'll see you next week.
All right.
Thank you, Your Honor. We'll see you next week at 9 a.m.
Pardon?
I said, thank you,
9
Your Honor.
a.m.
We'll see you next week at 9 a.m.
Thank
Yes,
you.
ma'am.
Thank you, Judge. Have a great day.
Yeah, you do the same. You do the same, bro, too. What? Okay. Who is?
Oh, my goodness. Christina Montez. Yes, nobody wants to see your boyfriend or whoever that is half dressed. I don't need to see that.
Sorry about that. He's not see. She can't see it like this. And the exceptional service.
Yes, no one needs to see that.
Sorry about that.
No problem.
Yeah.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have an
Yes,
idea.
ma'am.
Ms. Montez, you need to listen to the questions that I'm asking. That question was directed at your attorney. Do you understand?
I'm sorry, ma'am.
Ms. Kogut, have you received all the discovery in this case, and did you review it with your client?
I have an idea, Your Honor.
Court will find that the state is in compliance with discovery. Next, I'm going to show you what's entitled True Bill of Indictment, Ms. Montez. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we are, and also I want to mention, there's a couple corrections on the plea bargain that I need to let you know before we get to that.
All right, so you're proceeding on count 1 and 2? Count 1 is possession of methamphetamine, count 2 is possession of heroin.
We are proceeding on count 2, waiving count 1.
Any objection?
No, Your Honor.
All right, Ms. Montez, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in
Yes.
both places?
I'm sorry. Yes, ma'am.
You understand you're charged with possession of controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any
Yes.
reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and she was.
Ms. Montez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Ms. Montez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. The court is in receipt to this document, what's entitled plea bargain page. Are there corrections to the plea bargain agreement, state or defense?
There are, Judge, and I would ask if I could see you and defense counsel in the breakout room.
All right, we will go to breakout room number 2, please. Stand it.
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 2. Punishment is to be assessed at 1 year in the state jail facility. There's a $1,000 fine prorated. State recommends community supervision. There's $114 for SAPD drug testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of repeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation of 120 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, Ms. Montez, do me a favor. Concentrate on what's going on. Put the shades, glasses, whatever you have down. You can do those repair work on your own time. Do you understand?
Yes, ma'am.
State any evidence to support the defendant's no contest plea.
Yes, the state offers states Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor.
Ms. Montez, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I would ask the court to follow the plea bargain agreement.
All right, Ms. Montez. Who is Jacob Vasquez?
My boyfriend, ex-boyfriend.
What, do you guys live together or no?
We did up until yesterday.
What happened yesterday?
I guess bad breakup.
When's the last time you used drugs? And before you even answer, know that you're going to get drug tested today.
Yeah.
So what are you positive for today?
Whatever I was found with.
And what would that be? I wasn't with you, so I don't know what you were using.
Methamphetamines and And heroin.
Okay. So when did you last use?
That would be today.
Okay.
Well, actually, early this morning, about 3.
Or this afternoon?
Yeah, I haven't been. Honestly, I have not been to sleep since last night.
All right. So you last used this afternoon?
3
over the lunch break?
No, not over the lunch break. It was like 3 this morning.
Okay.
This morning.
Do you have any children?
Yes.
What are their ages?
3, 7, and 15.
And where are they?
They're with my mother and my mother-in-law.
So, and where is their father?
He's in prison.
Child Protective Services involved?
Yes.
So obviously you're not doing your service plan. Are you dependent on your mother to end up taking custody of your children?
Yes. Well, yeah. My mother-in-law has custody of my daughter, and my youngest is with my sister-in-law. And I have custody of my 13-year-old, but he's with my mother.
Well, you know your 15-year-old should not be with you at all.
Yeah, I know he's not. He's with my mom.
So basically your children are separated because you won't stop using drugs.
Yes.
Have you ever been to rehab?
Yes, yes, I have.
When?
I've been to SADF. I have been to the NICS. I've been to, when I was in drug court. That's right, I was in drug court. I was gonna check into the nearest methadone clinic. It's the methamphetamine is not a problem. It's the heroin that's the problem. And that's what I was gonna do this week when I got some money, some more. Actually, I'll just give funds right now.
Well, you know, methadone is just another drug.
Yes, I know that.
How far did you go in school?
Some college.
When did you first start using?
About 25.
Did you complete any services with Child Protective Services?
I had some parenting classes done, but I didn't complete no safety plan.
When's the last time you were employed?
2018, I believe.
How are you supporting yourself?
I clean houses.
How are you supporting your habit?
From that, I get paid on a cash level.
I'm sorry, what?
Cash. I get paid by cash. I clean houses and I get paid cash daily.
You're not going to be allowed to do that anymore. You understand why?
Because I have to get a job.
Well, you can't be any place in any employment that requires a fiduciary duty on your part. So I can't have you in someone's home cleaning houses when you're in the throes of your addiction, because when people are in the throes of their addiction, temptation is rampant, because you know, and I know that if you need a fix and there's some extra money laying around somebody's house, you're probably going to take it. So I'm going to get you some help. And whether or not you take it is 100% up to you. Either you're going to be a mother to your children or you're not. Right now, the problem is, I imagine your mother and your mother-in-law allow you to drop in to be the sunny delight mom with your children, but they do the heavy lifting. You just come in to breeze in, hey, to be the happy mom. They didn't want to be mothers to your grandchildren, to your children, but you've forced them to be mothers instead of grandparents. We're going to fix that today. And whether or not it's fixed depends completely on you. I see that drug court didn't work for you, so we're going to step that up a little bit. This is what the court is going to do. Sentence you to 18 months, suspended and probated for 2 years. There's to be no contact with Jacob Vasquez. $1,000 fine that will be probated. $114 to SAPD for restitution, 120 hours community service restitution. The court will deduct 40 of those hours if you receive the COVID vaccine. Not forcing you to do it, but if you do it and you provide proof, you'll have that. There's to be no unsupervised contact with any minors. There's to be intensive parenting classes, proof of employment within 30 days, no employment, Rebecca, as that requires her to be placed in the position of having a fiduciary duty. So there's no employment with her as a home health care provider, with minors, or house cleaning. You're going to report to court tomorrow at 9 a.m. That's October 1st, 2021 at 9 a.m. We're located at 300 Della Rosa.
Okay.
When are you going to report to court?
Tomorrow at 9 a.m.
And what's the address?
300 Della Rosa.
All right. You're going to report to court and you are going to be placed in Safe P. Once she's completed Safe P, I'm going to want the UA hotline. And I'm going to want field visits 3 times per month, random.
Ma'am, is there any way that I can get, because this is my house right now, I have to get, we're been in the throes of moving out. We're getting evicted and I literally had to move out.
Who is we?
Well, me and my ex-boyfriend, we just had a
No,
break.
so here's where you are, Miss Montez. You just used drugs this morning. You're telling me you haven't had any sleep because you keep using drugs.
No, this is
so here's the thing,
report.
Miss Montez, if I test you today, you're going to be positive for heroin and meth. Maybe alcohol, maybe marijuana, but we know heroin and meth. And let me explain something to you. The people who make the heroin and meth, that's not FDA approved. You don't know what they're putting in it. You don't know if you may overdose or not overdose. So I'm trying to save your life and help you. So at the end of the day, money should not be the driving force of our lives. As my mom always says, if you have a problem that money can't solve, then you have a real problem. And right now, the problem that you have that money can't solve right now is you're in the throes of your addiction. The fact that you may lose some furniture at your apartment or wherever you stand, that can be replaced, but your life can't. So you're going to be in the 187 District Court tomorrow at 9 a.m. promptly. If you don't show up at 9 a.m., what's going to happen is a warrant is going to be issued for your arrest. So she's going to show up at 9 a.m. tomorrow.
I can do the probation. I know I can do it. I know I could do it.
Yeah, you are going to do it. But this is the way you're doing it.
Without the Safe P. I have a lot of
Ms. Montez, let me ask you something. Are you clean right now? If you were drug tested today, would you be positive or negative? Yes or no?
Okay, I would be negative. But I mean,
no. Time out. Time out and listen to me.
Because I know
time out. Time out. Listen to me. You just told me you use drugs, so you're going to be positive for drugs. So here's my question for you. If you can write your own program and do it on your own, why are your children with your mom and with your mother-in-law? And why are you positive? Because you continue to use and you can't control it.
Let me explain. With my 5-year-old, my 7-year-old, my 3-year-old, I was ripped out of the house. I was ripped out of the house because my uncle and my brother-in-law at the time, they were in a quarrel. And my brother-in-law, he shot at my uncle. There's police reports on this. And there was a whole hostage situation. I was doing everything I needed to do for that child at the time.
Let me ask you this, Ms. Montez.
Yes,
I want to
ma'am.
ask you something. Let's say your children live with you.
I go to NA.
Nope. Listen to what I'm saying. Calm down and listen to what I'm saying.
Yes, ma'am.
Let's say your children live with you and you need a babysitter. And I come to you.
I'm not allowed to have my children.
Listen
I don't
to
have
me.
custody of my children, Ms. Boyd. I do not.
All right, she won't listen. This is what's going to happen. You're going to come in tomorrow at 9 a.m. If you're not here, a warrant is going to be issued for your arrest. So she's going to come into court, Rebecca. She's going to Safe P. Then after she gets out of Safe P, we're going to do a UA hotline. There's going to be 3 field visits per month. I'm going to want weekly in-person reporting until further notice. Is there anything else that she needs, Rebecca?
No, ma'am.
All right, Ms. Montes, unmute yourself. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Ms. Montes, here's the thing. You've been sick, and I put my fingers in quotations for that, since June 15, 2021. You've been using drugs since the date of this offense, and the date of this offense is December 6, 2020.
No, I have
You've
not.
had a full year and more to get in a program and do better, and you can't do it on your own. That's why I'm here to help you. I'm going to send you to breakout room number 1, and probation will go over conditions with you. If you do not show up for court tomorrow at 9 a.m., a warrant will be issued for your arrest. Ms. Kogut, if you can go to breakout room number 1, please, and let your client know. If she does not show, a warrant will be issued for her arrest.
May I say something, please? If the judge is there?
Yes, Ms. Long.
I've been sitting here for 3 hours. And I sat in your courtroom for 4 hours.
So what are you trying to say?
I understood that you're going to take a break and go to lunch, or?
Here's the thing. You need to be talking to your attorney about that.
I do.
And that's your attorney, right?
Yeah, I called him.
Yeah, so the court waits for your attorney to appear. I don't know why you act as though somehow this is my fault, and you're telling me you sat in my courtroom for 3 hours and now you've been on the Zoom for 9. How long do you think I've been here? How long do you think the court has been here? And yes, I am taking a break. I am taking a 5 minutes break because I've been here from 9 to 12. And actually, I started my day here in court at 8 a.m. So yes, I deserve to take a 5-minute break.
I didn't understand. Hello? All I want to do is enter a plea of not.
Cruz.
Hey, Miss.
Yes.
Hey, Miss, you about the nicest judge I've ever seen. Is a lot of these people are retarded, right? Like, fucking stupid. All right, thank you, Mom.
All right, have a good day. All right, the court is going to call 2019.
May I be excused?
Yes, you're excused. Thank you so much. Thank you for your patience.
Thank you.
All right.
Folks, my staff has reported that was you. And it appeared as though you were having on the screen.
No.
She understands them and at this time knowingly voluntarily waived them and lay a factual basis to the added count.
May I have her sworn? Raise your right hand. Do you solemnly swear and affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine.
You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy P 33014.
1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep. Yes, Your Honor. Yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form?
Yes, Your Honor.
Particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes.
And amphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. Then have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, well, go ahead, counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail. She's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently, she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. So what I am going to do, not on the defendant's motion, I'm going to adjourn this out to next week, the 5th. You'll have to appear in person, ma'am. That way we can assure you're not smoking and not having while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.